Good evening, everyone. Please confirm you can hear me. Perfect. Perfect. Okay, so welcome to week 2, everyone, and I hope this is going to. I welcome everybody once again. Thank you for taking out time from your busy schedule to join this second class of this ADR online program. And if you have anything to say, Dr. Tolu Aderemi, you have something to say before we kickstart because we are far behind time. Okay, I'll just read out the profile of our keynote speaker, and then I can just hand in the mic.
So just before
Please confirm you can hear me once again before I proceed.
Can you hear me?
Yes, sir.
Okay. All right. So good afternoon, everyone. Our structure is usually when we start, we'll give a welcome remarks, and then we'll read out the profile of the keynote speaker, which is what Kelvin is going to do very shortly. So I want to thank all of you for joining this meeting or this class early enough. I know that we're 15 minutes behind time, and we want to encourage everyone to please, let's ensure that we come into the class on time so that we can take good advantage of this short period, 60 minutes, and I think 30 minutes for question and answer. Secondly, the topic for this afternoon, like I put on the platform before, is on mediation. If you have followed international dispute resolution, you will see that globally, we're gradually moving away from litigation and even from arbitration, because we are beginning to see that some of our colleagues are abusing the process. And so what should otherwise have taken not more than 1 year, you discover that you are there 5, 6, 7 years, which defeats the entire essence of, swift dispute resolution. So this afternoon, Fola Alade is going to be talking about mediation, the art and the science of mediation. It's not all matters, like it is for arbitration, that mediation is suitable. But I would say that most matters you are likely to be able to get a headway for using mediation. So I want to urge you, please pay rapt attention to this particular class and interact with the lecturer. A lot. Fola is someone who is renowned in the mediation space. Is someone I have a lot of respect for, and I'd like you to please tap an amount of knowledge of him before we let him off the hook. Mr. Alade, I want to thank you very much for donating your time to this school and for this period you're going to be teaching this class, and essentially for everything you have done in helping us put this together. Ladies and gentlemen, I would handle you over to Fola Alade. Mr. Kelvin will read out his citation. Thank you.
Thank you so much.
Thank you very much, sir. Okay. Fola Alade is a globally respected commercial lawyer, Notary Public, and accredited attorney-mediator. With over 15 years of experience, he has built a remarkable career at the intersection of law, dispute resolution, and professional development. He is the principal partner of FOTEFA Partners LP and the founder of FOTEFA Mediation Academy. Appointed to the United Nations Global Mediation Panel, Fola has mediated complex disputes on behalf of multinational organizations, government institutions, and commercial entities across Africa. His expertise span commercial conflict, workplace mediation, MSME disputes, real estate settlements, and debt recovery. He is a panel mediator with Nigerian Court of Appeal, Federal High Court, and multiple states and arbitration centers across the world, an international certified trainer, emotional intelligence specialist, and mediation advocate. Fola is a fellow of ADR Society of Nigeria. He has judged numerous global mediation competitions and regularly facilitated courses in negotiation, mediation, and legal soft skills. Ladies and gentlemen, our Fola. Yes, we can.
Okay then. So good morning, good afternoon, good evening to everyone listening to me. My name is Fola Alade again, and I will be taking you on an introduction to mediation and mediation advocacy. Now, I think I would start off on this point by saying that there is nothing I'm going to say to you today that will make you a mediator or a mediation advocate. Because before you can become a certified mediator or a mediation advocate, you need to go into the training of becoming one. So as much as I may gloss through the mechanics of mediation, I think it's essentially very, very important that you have an understanding of what mediation really is all about. That's number one, for those that may want to venture into mediation. Secondly, for those that are already into mediation, that want to know what the prospects of mediation may be, this is also a very good avenue for doing so. Now, I remember some years ago when I approached Dr. Tolu because then when Dr. Tolu, I've always seen Dr. Tolu as, I like to call him in my mind, an arbitration guy, very big on arbitration and all that. And I, being a mediation guy too, I said to myself, it wouldn't even be a bad idea if practitioners of ADR come under one umbrella to start speaking the language of dispute resolution. And because one thing I've always had a problem with is the antagonism of some sort that goes on within the dispute resolution space, where practitioners of a particular dispute resolution believe that their own dispute resolution is better than the other dispute resolution, or they think one dispute resolution is weaker than the other. And so I've always had this belief that we're all doing the same thing, maybe in different ways. We could just possibly work together. Little did I know that Dr. Tolu would even want to come up with this beautiful initiative that I know will be an ultimate game changer. An ultimate game changer in the sense that we all can see ourselves as one, and that we're all practicing the same form of dispute resolution. Number two, again, is the trajectory that comes into place. And when I'm talking about trajectory, now I will be speaking on ADR. The trajectory is what I like to call the NMA approach, that when disputes come up, we start off with negotiation. And that was ably taken by Dr. Kola Mayomi. And so that shows Dr. Tolu's intentionality in coming up with this model. So if disputes come up, we start off with negotiation, and if negotiations don't work out, you then go to mediation. If mediation does not work out, then at that point, you may decide to go to arbitration or go to litigation. But I belong to the school of thought that is very big on specialization, and subject matter expertise, to the effect that on these different levels, you can actually practice whichever one you feel most comfortable with. So I'm sorry if you're expecting me to come here to say that, mediation is the next best thing since bread and butter. Yes, mediation works, but so does every other element of dispute resolution. So it then boils down to you all that are here to basically see what it is that you gravitate towards, and then make up your mind on what you want to do. So having said that much, I will go into today's session, which is introduction to mediation and mediation advocacy. Now, ladies and gentlemen, the starting point really is what I like to call the tree of ADR. And one of the reasons why I'm going back is that I understand that we have some law students and here final year law students and basically newbies who are venturing into the ADR space. So I'll please crave your indulgence to just piggyback a bit and then take us to where we are. Now, we have ADR, and ADR is essentially an acronym for alternative dispute resolution. Now, when we talk about alternative dispute resolution, what do we mean? Alternative dispute resolution is an acronym that talks about any means of settling disputes outside of the courtroom. Now, So what this invariably means, ladies and gentlemen, is that while we have litigation on one side, which essentially is a formal general public process by resolving disputes through a court with a judge or a jury, then we have the alternative to litigation, which is ADR. Now, please look at the word I'm using. We have what is called the tree of ADR. Now, ADR has so many branches. Not only arbitration, mediation, and negotiation alone. You know, we have conciliation, we have collaborative law, we even have the hybrid process of app med app. You know, so we have what is called the tree of ADR that has the branch of arbitration, that has the branch of negotiation, that has the branch of mediation, that has the branch of conciliation. Now, before I go deeper into that, I would like you to please have a look at what I have here. And this essentially is what we're talking about where ADR is concerned, that where dispute resolution comes into place. Disputants should have multiplicity of options. You know, based on whatever dispute they have, they should decide, okay, fine, I want to resolve a dispute either using arbitration, I want to resolve a dispute using mediation, I want to resolve a dispute using negotiation, and so many other things. And this was probably what gave birth to the multi-door courthouse, you know. And of course, what's the concept about the multi-door? That disputants should have multi-doors towards resolving disputes. Now, why this is essentially very, very important is because I see that there's always some kind of confusion where people assume that the synonym of arbitration is ADR. No. You know, so arbitration is a branch under the tree of ADR. And one of the reasons why it looks as if, and why arbitration is also very, very, very popular is because it shares certain similarities with litigation. And that's why if you look at what we have here, we have arbitration being a simplified means of trial without the technicalities of litigation. And what this does is that it empowers third parties to decide the outcome of a dispute. So now, while the end product of mediation is the terms of settlement, the end product of litigation is judgment. The end product of arbitration is an award. You know, so while we have mediators, mediation, we have judges for litigation, we have arbitrators for arbitration. Now, the interesting thing, ladies and gentlemen, and I'm still going to go deeper into this as we proceed, is that now ADR, unlike litigation, has also opened the floodgates for non-lawyers to come into play. So what this essentially means is that coming down to resolving disputes is no longer the purview of lawyers alone. No, we have so many non-lawyers coming to the ADR space to resolve disputes. And I dare say that a lot of them are doing this job very, very, very well. I'll still go deeper into that. Now, having given that background, ladies and gentlemen, I'm going to go into the topic of today. What is mediation? So like I said, the whole idea about today's masterclass is to just give an insight into the benefits of mediation, to also create a balanced perspective for participants to then make up their minds, excuse me, on what it is they want to do, whether they want to go into arbitration, whether they want to go into mediation, and for the superhuman people that can manage both of them together, at least you have a balanced, you have a balanced information on how both of them are like. So having said that much, what is mediation? Mediation can be defined as an amicable way of resolving disputes using a third-party neutral. Mediation can be defined to be a voluntary and private dispute resolution in which a trained neutral helps parties to reach a negotiated settlement. Now, I would please crave the indulgence of everyone present, because for me, engagement is the strength of clarity. As I'm dropping the nugget, if there are certain statements I make that resonate with you, kindly please just put them in the comment section, you know, so that people can read and resonate with them. So like I said, so having said that much, it's also an opportunity to resolve a dispute without resorting to formal procedure. Ladies and gentlemen, that is what mediation really is all about. Now, what are the features of mediation? Number one, mediation is a flexible process. And I dare say that it's one of the reasons why some of us came into mediation, the flexibility involved. And when I'm talking about flexibility, what do I mean? I'm so sorry. What do I mean when I talk about flexibility? You can file a process in court, make your claims, and then when you get to mediation and make your claims stating certain demands, and at the end of the day, what the parties may agree upon may be totally outside what has been filed. That's what makes it flexible. Number two is this. Now, more often than not, so some parties may just decide, okay, no, let me piggyback a bit by using this example. Now, conventionally, when debt is owed, you naturally expect the debtor to be the creditor to be the one to take the debtor to court. But whereas in mediation, the debtor the creditor can take the party to mediation. Why? Because they want to agree on the modalities among so many other things. And I dare tell you that the flexible mediator happens to be one of the best mediators that come into the sessions with an open mind. Now, one of the cornerstones of mediation, ladies and gentlemen, is confidentiality. And that is why we don't have judicial precedent. That is why you don't have a one-size-fits-all. Anything that is said within the confines of a mediation session ends in a mediation session. Why? Because the parties sign the agreements and whatnot. Now, the mediator is a neutral person. Neutrality in the sense that he does not bandy to what either of the parties say. Essentially, his job is that he actively assists parties in working towards a negotiated agreement. So a mediator is a facilitator. What a mediator, well, we call him a neutral, because that's essentially what he does. Now, one thing mediation standout, ladies and gentlemen, is that the parties are in ultimate control of the decisions they take to settle. So that means that unlike the convention, unlike litigation where you have the lawyer speaking on behalf of the parties, in mediation, the reverse is the case. Of course, we have the lawyers being actively involved, but more often than not, they take center stage. It's essentially what it is that they want, with the mediator then guiding both of them towards an amicable resolution. And it's also a voluntary process. Now, when we talk about it being a voluntary process, what this essentially means is that the parties can decide at any point in time before they sign the terms of settlement to not continue with the mediation. Now, unfortunately, the issue of voluntariness can be a shield and can be a sword, and this is something that parties I like to call them mischief makers try to use as an argument against mediation, and I'll tell you why. Now, when it comes to litigation, once the other side has been served, with necessary processes and whatnot, it behoves on you to file a defense. If you don't file a defense, a judgment can be gotten against you. Same thing for as arbitration too. Now, even with litigation, you can be compelled to come to court, but mediation is not like that. It's voluntary, and it necessarily means that at any point in time you can. But you see, the voluntariness of mediation is also one of the strengths of mediation. Why? Because if the parties of their own volition are able to agree on terms, those terms, when adopted into a consent judgment, is binding upon both parties. Now, ladies and gentlemen, I'm just going to be having a heart-to-heart conversation, and some of the things I may say, some of them are subjective, but more often than not, when parties agree on what works for them, rarely do they appeal? Because ask yourself one question: is there always an appeal? Because there's some kind of level of dissatisfaction with the judgment of the lower court. Now, say for when parties enter into some form of terms of settlement, when under duress, when they are able to prove the doctrine of a non-ex factum, more than not, when parties consent judgments are rarely appealed against them. And these are one of the features of these are the many features of mediation. Now, there are certain words that I will be using interchangeably. And while I continue, Mr. Kelvin, I know people can't unmute themselves. Can you please confirm if I'm still audible so that I know that I'm still being heard? So now, there are certain words that I will be using. If I am, Okay, thank you so much. Yeah. Now, there are certain words I will be using interchangeably, and it's very important that you all understand what some of these words mean. One, when we talk about a mediator, who is a mediator? Now, a mediator is a neutral third party, and essentially his job is to assist parties in a dispute towards a settlement. Now, like I said earlier on, the job of a mediator is that he's an independent person and he must act an impartial manner. Understand that a mediator is not a judge. He cannot pronounce punishments, neither can he pronounce sentences. His job essentially is a facilitator. Now, he uses certain skills that help him to help disputing parties resolve disputes. And this is why I always struggle when I see misunderstandings between two people, and then some third party comes in and then resolves the dispute, and he says that he has mediated. No, he hasn't mediated. Now, you see, there is a structure towards resolving disputes. And you see that structure that mediator brings into play is what makes it mediation. Now, please understand that that mediator has been trained in the art of resolving disputes. And that's why if you now decide to go deeper into what I like to call the mechanics of mediation, you'll find out that there are certain, there's a trajectory to be followed. You know, more often than not, you have what is called the preparation, which is what the mediator does by, first of all, going through the case file to have an understanding of what it is. You know, and then we have what's called the opening statement. Now, what is the opening statement? This is when the mediator basically explains to the parties what the issues and content. Well, he explains to the parties what mediation is all about. He tells them about the cornerstone of mediation. He basically gives them the ground rules and basically sets the tone how the session will be. He then explains the phases of mediation, which are essentially three phases. You have what is called the plenary or the introductory phase. This is where the parties get to tell the mediator what the issues are and what they want from the mediation session. It's also very important to state that as mediation is party-driven, you know, legalese is toned down to the barest minimum. So you find out that parties only focus mostly on facts, as it should be. So it is at the opening, it's at that point that the parties tell the I mentioned the introduction. Yes, it's at that point that the parties say what the issues are and what they want from the mediation session. Now, once they're done with the introductory phase, the next step they will go into is what's called the caucusing, which is a private and confidential session that the mediator can have with either of the parties. And please understand that the mediator has the right to exercise his discretion on which of the parties he wants to have it with. Maybe he wants to have it with party or counsel, depending on the tone. And hopefully, he then moves to the concluding phase. Now, all of these are the steps that are followed. Of course, you have the agenda. You know, this is where the mediator finds out what the issues are, and he then walks the parties towards an amicable resolution of issues. You know, you have what is called positions, which is where the parties state their demands in terms of what they want. But you see, a good mediator takes the piece from the position to the interest. Now, like I said, I'm trying so hard not to go deep into the mechanics of mediation, because you see, it's going to take this conversation to another, and I don't have that much time. You know, so I haven't said, so these are the things that make a mediator stand out. The structure he brings into dispute resolution. Now, one word that is coming up that I really don't know whether some of you know is what is called mediation advocacy. Now, when we're talking about mediation advocacy, what does that mean? You see, a mediation advocate really is a lawyer who represents his clients at mediation. Now, the same way you have lawyers representing clients in courts, it is also the same way you have lawyers representing their clients in mediation. Now, the dynamics are a bit different in the sense that, you see, as much as the lawyers are representing the parties in mediation, they do so with the mindset of an amicable resolution of the issues in contention. So a mediator is a neutral, you know, he doesn't take a position. A mediation advocate represents his client with a mindset of an amicable way of having the dispute resolved. Now that SCMA standards, which are known as the standard reference of mediation advocates, they have defined to be a lawyer, and they have defined a mediation advisor to be a non-lawyer that represents his client at mediation. Now, this also boils down to what I spoke about when I was talking about the concept of ADR, opening the floodgate for lawyers and non-lawyers to come in, which I say is a good thing. Now, why extensive training on the acts of mediation and mediation advocacy, why it's very, very important is that they teach you the structure that comes into resolving disputes where mediation is concerned. Now, when it comes to mediation advocacy, the dynamics are slightly different because the bulk of the work of a mediation advocate, not even done right there in mediation, is done pre-mediation, where you are able to help the client put his case in proper perspective. So like I said, the essence of today's session is just give you tidbits, insight into some of these things and what to expect when you then decide to take a full course in mediation. Now, having said that much, I'm sure the next question, and I must also add that the intent of today's webinar really is what I like to call a cocktail of frequently asked questions, questions asked by people. Now, I'm sure the next question will be, okay, having said that much, then do you become a mediator and or a mediation advocate? Now, first things first, you have to take professional certification courses in mediation, and that is when you can then say you're an accredited mediator or an accredited mediation advocate. Now, I'm sure the next question will be, okay, fine. So Fola, so which organization would you advise that I train with? I may not be able to answer that question. And I'll tell you why. Because I train with over, last time I checked, I trained with over 12 ADR organizations around the world. So, but I will give you insight into what to look out for when you decide you want to train with any ADR organization. You see, ladies and gentlemen, anybody can train you on mediation. But you see, mediation is like a verb. What you should look out for is any ADR organization that has an enabling environment for you to practice what you have been taught. And I'll tell you one thing for free. You see, mediation is a verb. Now, when I'm talking about it, it's a moving word. Any certification you get, any training you get, ladies and gentlemen, I don't mean to shock you. It's just maybe 2%. In fact, the moment you become a mediator, the moment you decide to come into mediation to become a mediator, if it were to be a computer game, I'll tell you it's just level 1. Because the thing about mediation is that it's like a gift that keeps on giving. It's like an onion that has several layers, So the certification is not, it's not the finish line. I dare say it's just the starting point, because you see, the beauty about mediation is that and that's why sometimes they call it mediation skills training. It's a skill. And one thing you all need to know about the skill is that you only get better when you practice what you have been taught. So you can only become a good mediator when you mediate. Now, at the risk of putting some ADR organizations on the spot, some ADR organizations are just in the business of training. What they do is they train you to become a mediator, and then they leave you, then they let you be. Now, of course, some mediation practitioners also struggle with the fact that, okay, I'm a mediator. I've been trained to become a mediator. I'm not able to practice what I have been taught. So these are the things you need to put into place. First of all, to know whether the organization, has enabling environment. And it does not necessarily even have to do with sometimes life cases. It could just be maybe simulations and whatnot. So like I said, you have only completed, if and when you decide to go down the lane of mediation, what you have been able to do is to just complete your mediation training. But you see, mastery begins after certification. Now that is where the real work is. And I would like to first of all apologize in advance for certain things I'm going to say, because I think the truth must be said. You see, people come into mediation and they say, oh, I want to make money, which, trust me, is the reason why I came into mediation. I'm so unapologetic about the fact that I'm a businessman disguised as a lawyer, the businessman disguised as a mediator. If it is not making money, it's not making sense. But you see, there's the place of making money, and there's also the place of value. But a lot of times what we see people doing is that they come in, they want to chase money, when in actual fact, what you should chase is value. When you chase value, you attract wealth. Now, it may interest you that the single most important thing you may take out of today's class may just be this: having a pen and a jotter. You will not, as I go deeper into this, you will know why it is very important for you to get yourself a diary and then a pen. I will go deeper into this. So like I said, what I have here is that one, learning does not end with a certificate on the wall, but continues in practice, reflection, and exchange with peers. You need to refine your craft, strengthen your professional presence, and then reconnect with the community that speaks your language. Ladies and gentlemen, the summary of what I have here is that you must have a plan. And that's the biggest problem a lot of people have when they come into the ADR space. And please understand that a lot of what I'm saying right now does not even only apply to mediation, applies to arbitration, applies to any other thing you want to do. You understand? You must have a plan. Because if you don't have a plan, how do you want to measure growth? If you don't have a plan, how do you even want to know what it is you want to do? A research was done and said that before you can become the master of anything at all, you need to give that thing 15 years. But I dare say that with the level of technology, with the level of conscious trainings like this, all thanks to Dr. Tolu, you may not even need up to 10 years, but you at least need to put in some years. Someone said maybe 10. No, you don't even put in 15, maybe 10. But the point is that you need to have a plan. Short, medium, and long-term plan. What's the short-term plan? Accreditation, become an accredited mediator. The second plan, within the short-term plan, which you may probably put in for like maybe a year or 2 years, try and gain the knowledge. You understand? Understand the practice of mediation. Go all in. And that's why, I'll be very honest with you, I respect those that can multitask. For someone like myself, I eat, drink, sleep, mediation. I have no atom of addiction or litigation in me. Litigation for the first 10 years of my active legal practice. I worked in a law firm that had the highest number of sitting SANs. We had fellows who were arbitrators, but somehow, some way, I did not connect with it. And what am I trying to explain to you? You see, there is money in everything, and I think it's extremely important, ladies and gentlemen, that you find something you enjoy to do. And because you see, nothing good in life comes easy. You need to enjoy what it is that you do. If it's arbitration you enjoy, go all in into arbitration. If it is mediation you enjoy, go all in into mediation. First of all, gain the knowledge. When the next question now you ask yourself is, how then do you make money from mediation or make money from arbitration? But you see, you need to have a plan, have an understanding of what mediation is all about. Apart from even having an understanding of what mediation is all about, know which way you want to apply mediation into. And I'll tell you one thing for free. I know I'm going to say it there, but now that it's coming to mind, let me just quickly say it here and there. Ladies and gentlemen, you see, ADR passes the test of universality. Mediation. So if ADR passes the test of universality, if the tree of ADR passes the test of universality, then that means every branch of ADR, arbitration, mediation, negotiation, passes the test of universality. And what do I mean when I'm talking about the test of universality? That means that a mediator in Nigeria is a mediator in the UK, is a mediator in Ghana, is a mediator everywhere. So that means that everyone who is practicing ADR is a global person. But how many of you call yourself global mediators, call yourself global arbitration? Ladies and gentlemen, that is the language of the 21st century. And I say this carefully to working on eggshells. You see, you are anything that you cannot practice anywhere around the world, you understand, makes you a bit endangered. So, but when you're coming into the ADR space, you're coming in there because you have been empowered with a tool that you can use practically anywhere. Now, the metaphor I like to use for this analogy of mediation is the fact that you are like a big gen that can power an estate. But yet, the only thing you do is to just probably use it for an apartment. When I'm talking about an apartment, if at the end of the day, you can practice mediation practically anywhere around the world, why are you limiting mediation to only Nigeria? Why are you limiting mediation to only Lagos? Why are you limiting arbitration to only... So whatever it's like about mediation, ladies and gentlemen, also works for arbitration, exactly. And I would also let you know what the differences may be. So everything, ladies and gentlemen, is mindset. You see, that's why it's very, very important, mind over matter. Everything starts first in the mind. How do you see yourself? What is the plan? When you get tired, not if, when you get tired, what are you going to fall back on to see how far you have gone? A lot of people come into the mediation space. Once they are not able to find their footing, they run away and say, oh, there's no money in mediation. Oh, there's no money in this one. We have so many people working on this. And for those that are reading the comments, you need to understand one thing. We are in an era of specialization now. Generalization is not an advisable place to be. That is the only reason why right now you have people offering lawyers peanuts. Why? Because we have so many people doing it. So now, if I remember, I know if you're supposed to draft an agreement, you're supposed to take 10%. But you and I know that if you tell parties 10%, they will tell you there's another lawyer that can take 5%. And the interesting thing is that no matter how low you go, there's always going to be a lawyer that will go lower until it gets into oil. So you have to understand that, look, you see, you have to be, there's something that they call rarity of value. Value, you understand? Try and get to that level of specialization. If it's mediation you want to go into, go all into mediation. If it's arbitration you want to go into, go all into arbitration. You know, we need to start having conversations about specialization. We need to start having conversations about subject matter expertise. Why? Because the future of work has changed. But I'm not even going to go into all of that. Now, let's now come back into some of the benefits of mediation over litigation. First of all, like I said, all of them are efficient, you know, but for the purpose of this, I'm just basically trying to distinguish mediation from litigation. First of all, while litigation looks to find fault, you know, it's always a case of, okay, you did XYZ, XYZ, you understand? On the basis of XYZ, XYZ, now you're not getting judgment, you know. But where mediation is concerned, mediation does not do that. It's always a case of, okay, fine, this has happened. So how then do we take this conversation from point A to point B? Mediation, ladies and gentlemen, is forward ever, you know, backward never. And I dare say that this right here, ladies and gentlemen, for me, is the biggest selling point of mediation: speed. Please pardon the mischief in having flash here, but you see, this right here, ladies and gentlemen, is the language of the 21st century. Now, please understand that where we are right now, the conversation is not about efficiency, because clearly they're all efficient. Mediation is efficient, litigation is efficient, arbitration is efficient. But you see, but I know we have some seasoned mediators here. I think I saw Mr. Okono and 1 or 2 or 3 other seasoned mediators. These are mediators that have seen resolve cases under 2 or 3 hours. And I ask, can you do that in litigation? Can you do that in arbitration? Ladies and gentlemen, you see, so speed right there is the language of the 21st century. You understand? The fact that parties can resolve disputes within a particular period of time. I'm still going to go in depth into speed, because you see, this right here is what makes mediation stand out. You know, speed, the fact that you're able to have disputes resolved amicably. And of course, it is usually less expensive than litigation, which goes all the way to judgment. You know, you start a case off from the magistrate court, you go to the high court. High court, you go to the Court of Appeal. Court of Appeal, you go to the Court of Appeal, you go to the Supreme Court. You know, that's usually the trajectory. But ladies and gentlemen, with mediation, it can end there. Now, when we're talking about costs, I'm not even talking about cost in terms of money. I'm talking about cost in terms of time. You know, you can win the battle and lose the war. You know, so these are things and when I'm even talking about cost, it's not necessarily from the position of being cheap, but sometimes from the position of affordability. Now, another distinctive feature of mediation is the options it brings into place, you know, because the parties are provided with a range of options, solutions, you know, that they come up with. You know, we try option A. If option A does not work, we look at option B. If option B does not work, we look at option C. You know, those are the things that come into play, and and that is one of the things that make mediation unique. Now, what are the types of cases that can be resolved through mediation? You know, we have property disputes. You know, it could be landlord-tenant case. It could be real estate issues. These are issues that can be resolved under mediation. We have debt recovery. Like I would say, I don't know, I may be wrong, but if we look at where debt recovery is concerned, you have the principal, you have your interest, and you have, and apart from the principal, you have interest. You understand? But the point is that more often than not, the issues are very, very narrow. You know, these are issues that once the parties are able to agree upon. I'm not trying to be that simplistic, but the issues are quite narrow. We have construction disputes, we have libel and slander, we have medical negligence, we have accident and torts. Ladies and gentlemen, I dare say that pretty much most of the cases that go into litigation are also cases that can be resolved through mediation. You have banking, insurance, you have family disputes, marital disputes. And I must also state here and there that even though mediation cannot dissolve a marriage, but mediation can be used to solve the contentious issues in the dissolution of marriages. And when we're talking about contentious issues, what am I talking about? I'm talking about custody, I'm talking about maintenance, I'm talking about access. You know, the parties are able to agree upon it, and whatever they agree upon is adopted as consent judgment between both parties. Now, mind you, because the courts are courts of public record, and for my learned colleagues here that are active, you know, back then, I used to do it if I had a matter that was going to go on at maybe 11 o'clock or 12, and I probably got to court early enough. Those in active party will tell you that the most interesting courts to go and sit down in divorce courts or family dispute courts, where you just sit back and then you hear parties washing the dirty linens in public. That really never happens. Where when you infuse mediation into all of this, you have landlord and tenants, administration of estates. I was doing something similar to this at the Court of Appeal before washing down here for the masterclass. So these are the issues that you can actually use mediation in resolving. Now, the question that we should then ask ourselves now is this: with all this, why mediation? Ladies and gentlemen, please let me introduce you to our present day reality. And I'm careful to say this, that the congestion, what we have, I don't believe that we have a delay in the court system. I think basically I would rather use the word congestion, and the metaphor that I would put into place really would be the traffic congestion. Try and imagine, we all see the traffic that is always going on roads and whatnot, but imagine a scenario whereby we had other means of transportation working. We had waterways, we had rails, we had effective public transportation. Most people would not even need to take their cars out because they can actually look at other options. Now, try and bring that analogy into dispute resolution, where we have mediation, effectively resolving disputes, we have arbitration, we have conciliation and whatnot. Because you see, why we have congestion is that we have more cases coming in than those going out. I still remember back then in active practice, you pick up a bar list, you see 25, 27 cases, you see 30 cases, you have the bar list, and let's be honest, there's so much the judges can do. You understand? There's so much they can do. So that's why when we have conversations around this, I belong to that school of thought that the judges should handle very serious cases, not when, and most of the cases that have had cause to handle in mediation are cases that I don't think should even smell the four walls of a courtroom. They should not. So when you now bring in mediation into all of this, it's able to help you sift it out. Now, if we now even decide, ladies and gentlemen, to then even look at the breakdown of what usually happens, more often than not, we have, I think, the court in a year sit for 104 days, Let's look at the breakdown. You have the public holidays, 10 days. You have the annual court, 60 days. Christmas vacation, 14 days. Easter vacation, 14 days. Conference week, 52 days. Ladies and gentlemen, I've not factored civil unrest. I've not factored strike, among so many other things. So these are militating factors that cause congestion. Then even about, if I'm going to even talk about the Court of Appeal, come next year, ladies and gentlemen, it's going to be the year of elections. And what does that mean is that, what that invariably means is that, of course, we're going to have election petitions. And so when we do, most times we have high court judges who are members of the election tribunal. And because there's a time frame ascribed to it, they're usually given priority. So what this essentially means is that sometimes some cases are adjourned sine die. Now, ladies and gentlemen, now let us not even then take this, because you see, we are dispute resolution, we are service providers. So try and imagine a scenario whereby the disputants have actually put a time frame within which they can have the disputes resolved. But with all of this, it's next to impossible to be done. And that's why in defense of lawyers, there's so much you can do. How many affidavits of urgency can you file? And so there's so much they can do. And that's why sometimes I tell people, lawyers not be James Bond. They can only, they will try their best, but at the end of the day, sadly, it is what it is. Now, like I said, my webinar is just basically a cocktail of frequently asked questions, and I'm trying to work with time. So how then do you refer a case to mediation? There are essentially 4 ways, by which you can refer a case to mediation. Now, I didn't put the third one here, walk-in. By walk-in, you can walk into any ADR organization and tell them you want to resolve the dispute. You can walk in to the LMDC. Now, the ones that a lot of people are quite familiar with is court-referred ones, whereby you have cases whereby the judge, in his or her discretion, can have the case referred to mediation. And then we have where the director of the Lagos multi-door courthouse can, or any multi-door courthouse can look at any contentious issue and then exercise his or her discretion. Or then you have maybe private mediation, you understand, where the parties can elect to have a private mediator to handle their case, among so many other things. So one of the reasons why I decided to just give a background to some of the things that come into place in mediation is just basically to give you an insight into what comes into place. Now we're going to talk about my own favorite part about what we're going to talk about, which is basically the business of mediation. Because let's be honest, learned colleagues, you see, if we are going to have to, ADR does not come cheap. both in terms of you wanting to become an arbitrator, you want to come into mediation. These things don't come cheap. So if you're going to have to invest money, invest time, invest energy, you need to have an idea of what it is you're getting into. Because at the end of the day, when you invest, there's something that's called return on investment. And of course, this business also ties into what I like to call the sweet spot. When I'm talking about the sweet spot is that, you need to know what you gravitate towards. I'll be very honest with you, we all can't be arbitrators. We all can't be mediators. We all can't be negotiators. So this is where self-awareness comes into place. You understand? Which of them do you know that you can do? And we have some people that are very, very good at multitasking. They are able to multitask. But I've seen from practical experience that, look, even mediation alone, I've barely mediation consistently for 10 years. And I barely. So when I hear of people doing all of that things in my mind, I'm like, wow, then these people are they're very, very, very good. Now, but the first question you need to ask yourself is this: what is your why? Because why this is very, very important is that it sets the tone for whatever it is you want to do. Now, you're coming into the ADR space. You've been able to identify the various branches of ADR. So is it and or or? You understand? When I mean and, are you coming into the ADR space to do arbitration and mediation? Are you coming to the ADR space to do arbitration or mediation? Ladies and gentlemen, you're the only one that can answer that question yourself. You understand? If you now say you want to come into arbitration, the question is why arbitration and not mediation? If you want to come into mediation, the next question is why mediation and not arbitration? You are the only one that can answer this question yourself. And that is why whenever you want to have this brutal, and that's why I want once again commend Dr. Tolu for coming up with this, because you see, the area of trainers that are coming into play over the next 10 weeks, ladies and gentlemen, we're talking about the best of the best. And they're coming in to give you insights on comprehensively on arbitration or mediation, so that by the time you are done, you have an informed knowledge on whether you feel you can go into both or you just want to choose one. So your why is very, very important. And apart from your why again, then your mindset too. Are you coming into ADL or with specific reference to mediation because it's a retirement plan? Is it a vocation? Is it the retirement plan? Are you coming in because you want to make money from it? We need to have these brutal conversations with ourselves. Why are you doing this? If you're going to come in as a retirement plan, the mindset is different if you're coming in as a retirement plan, because you're basically coming in to while away time. If you're coming in because you want to make money from mediation, the mindset is also equally different. And you see, why all of this is also very, very important, ladies and gentlemen, is because the future of justice has changed. We are now talking about online dispute resolution. Everything now is powered by technology. Technology is basically shaping the dispute resolution ecosystem. We're having ChatGPT, we're having Gemini. Now, back then, clients would ask for opinions on legal issues. Now some of them don't even anymore. What do? They go on ChatGPT. They type whatever the legal issues they have, they put it there. Even down to reviewing agreements, ladies and gentlemen, there are certain forms that you can put on Gemini, put on ChatGPT that can highlight the red flags and potential pitfalls in an agreement. So you can now see how all of this is changing. And that is where ADR comes into place, because you're coming into ADR from the comfort of your home. You can practice whatever it is you do from anywhere around the world. And it is no wonder why we have this kind of picture. We are beginning to have artificial intelligence law firms. We're beginning to have softwares that can actually literally draft agreements for you and whatnot. Ladies and gentlemen, I kid you not. If anybody had a plan 2-3 years ago for where we are right now, I'm sure a lot of them would have had to change their plans. Intellectual property right now has been redefined. You see AI, you can try to imagine a scenario whereby you're in your house right now, somebody will clone you to be somewhere else. Everything has changed. Everything has changed. But the question now is this: are you moving with time? That's the question. Are you moving with time? And that is why if you're coming into ADR, coming into mediation, you need to be passionate. You need to be hardworking. You need to have that drive. Apart from having all of this, you need to have a journal. The question I always ask is, what is the plan? Because you see, ladies and gentlemen, when you don't even have a plan, it is a plan in itself. And the interesting thing is that even the definition of illiteracy has changed. Back then, being an illiterate was said to be someone that could not read or write. But in the words of a futurist, I think was Alvin Toffler, he has defined illiteracy as the inability of someone to learn, unlearn, and relearn. You have to learn, you have to unlearn, you have to relearn. So that's why the conversation we're having around mediation, ladies and gentlemen, is not the conversation that is limited to only Nigeria alone. It's a conversation that we're looking at globally. Now, I ask you one question. Why do we think Nigeria matters in global mediation? Ladies and gentlemen, we have the numbers to over 240. Nigeria plays heavily in regional commerce, international partnerships and cross-border investments. Now most agreements have the standard dispute resolution clause, the NMA approach, negotiation, mediation, arbitration, and they are taking it very, very seriously. Back then they had this clause to tick the boxes. No, it's no longer like that. Now the parties are now saying, okay, fine, we're going to try negotiation, and we're going to see whether negotiation works. If negotiation does not work, we're going to come down to mediation. We're going to try mediation. If mediation does not work, we're going to look at arbitration. And I'll tell you why this is so, because now they are beginning to look at the cost-benefit analysis of having a case in court for years without end. Now, they are beginning to put, you understand, the fees on some kind of graph. They're asking the questions. And of course, the clients are now more enlightened. They are weighing all of these things. So these are the things that are put into place. So right now, most times, most agreements have the standard, NMA. So, and as global disputes are now becoming more complex, and with Nigeria's participation in mediation, and not only just arbitration alone, it is critical for regional and global stability. Now, like I said, I just also alluded to the issue of numbers. And I'll tell you one thing for free, ladies and gentlemen. Africa is the future, whichever way and manner you want to look at it. One, we have the numbers. We consume. We consume more than we produce. So while most countries are thinking, so what is happening right now, all focus is on Africa. What can we bring into Africa? How can we make things done? And in doing this, ladies and gentlemen, they're looking at, most times what they look at is the enabling law. You understand? If issues are bound, and issues will abound, how well can these issues be resolved amicably? We're not having fintech, we're having tech construction, we're having energy. Ladies and gentlemen, the conversation is out of the hinges. And of course, we cannot even talk about this without even some institutional foundations that are coming into play. When I'm talking about institutional foundations, we have the Arbitration and Mediation Act, which was enacted in 2023. And you know what it did? It formally recognized mediation as a standalone process. Apart from even recognizing mediation as a standalone process, it supports and enforces mediated settlement agreements. So right now, the misconceived, mischievous notion that mediation is not binding has been put to rest, that mediation, yes, is binding. Now, a lot happened for mediation in 2023, because in 2020, the same 2023, the Singapore Convention on Mediation, in which uniform and efficient framework for international settlements, resulting from mediation. What essentially means is that now, if countries are signatories to the Singapore Convention, they can actually be enforced outside the country, provided it is in the country provided it's in the country that has been ratified. And on November 27th, 2023, Nigeria then became the 13th state, you understand, to be ratified under the Singapore Convention. So having said that much, you can now see how the legal framework is also coming into play. Then how about then setting up a mediation practice? It's important that you understand that mediation as a concept does not stand in isolation. It must lean on something, So if you're coming into mediation, are you looking at the areas of specialization that I mentioned? Is it debt recovery? Is it landlord and tenant? Is it construction? Is it maritime? Is it oil and gas? But you see, before we even have any conversation about the business of mediation, one thing that's integral is the issue of competency. You need to be competent. You need to know what it is. And I'll tell you one thing for free. You see, where value is concerned, even if they're going to allude to the price, more often than not, it is never from the position of you being expensive. It's always the position of them not being able to afford you. And I'll tell you one thing for free. You see, when you are operating at that level, you understand, whereby it is quality over quantity, the conversation is different. You are not cutting down your price because you know that there's somebody out there that can do another job, that can do it better than yourself, you understand. And that is why I tell people one thing. You see, when you go deep into ADR, at the end of the day, the men are separated from the boys, because you see, what you know, what you have, and there's a level of abstraction that is ascribed to service, to service, that when people see you, or when people see you, when they hear you speak, they know that you know what it is. But it's also very, very important that these things are put in proper perspective. You understand? Like I keep saying, plan, plan, plan. Now, I'm so sorry, Mr. Kelvin. You know, we started at 4:20, so 4:20. So that 20 minutes that you took from me, I'm going to take it back. So I'll just try and run through all of this, and rather than having the questions and answers for 30 minutes, we'll see how we can work with 20 minutes, because it's really very important that a lot of us get what is being said today. Now, what then are the careers that you can have in mediation? First, being a mediator. Now, I'm going to take time out to break this down because, like I said, this is commercial mediation. This is where we talk about the real thing. Making money. First of all, when you decide to become a mediator, now you can become a mediator, ladies and gentlemen, with as many multi-door houses as possible. You can become a mediator with as many ADR organizations around the world. And do you know what they would ask for? Most times they only ask for two things. They ask for your experience, and which most times even trumps the organization that trained you, because they would want to find out how many mediation cases you've handled. So the question I'm asking, a rhetorical question, why you limit yourself to Nigeria? You understand? Why are you not throwing your applications everywhere around the world? You know why? The principles are the same. Understand? The same preparation, opening, agenda, interest, options, agreement. You understand? It is the same way you mediate in one country that you mediate in another country. But you know what makes mediation different? Two things. One, what I like to call cultural intelligence. And the second, again, is the style. But essentially the trainings are the same. Which is why you are able, which is why when you train with, because I train with quite a lot of organizations, it's principally the same thing. So have an understanding on the fact that, first of all, in Nigeria, you can belong to as many ADR organizations as possible. You can use the same certification to join as many ADR organizations around the world. Then mediation advocacy. Now, I'll tell you one thing for free. There's a tendency for you as a lawyer to make more money from mediation advocacy than you make from being a mediator. Why? Because when the parties come to meet you, they are coming to meet you with their own problem that they need to be resolved. So even if you are going to suggest an amicable way of having the issues resolved, you cannot, in practice, when you're talking about neutrality, they don't understand what that means. They're like, okay, fine, I've come to meet you to resolve a dispute for me. You are telling me now that because you are a mediator, you want to remain neutral. They'd rather find another lawyer to do it. So which is why, when you're coming into mediation, it's best to be empowered with the tool of being a mediator and being a mediation advocate, so that you know the caps to take off. So of course, I've been able to define what mediation advocacy is all about. And yes, when you have that, most times when they come, they tell you, okay, fine, we want to go to court. Yes, you can go to court. You understand? But of course, you know that at some point in time, the court would refer you to mediation. And I'll tell you one thing for free. I understand the constraints that come with being a lawyer and suggesting mediation. Now, you know that this is a case that can be effectively resolved. But let me tell you what the parties here. My case is either too weak or this lawyer does not know what he's doing. So that is what sometimes they hear. So you need to know how to balance conversations like this, and that's why I always say that the way you see mediation, the way you see amicable resolution of disputes, the parties don't see it like that. They believe, oh, if I make any moves towards resolving the dispute, the other party may see me as being weak. So of course, you can also have an independent mediation practice. I run a commercial mediation practice, you understand? You can be an ADR consultant. You can be an expert mediator in a certain niche. So you can see what I'm talking about. So this is not even about being specializing in ADR and saying you want to come into arbitration, you want to come into mediation. It even means within the framework of mediation, you are probably taking a niche, probably taking real estate, taking discourse, taking construction. And I'll tell you one thing for free, ladies and gentlemen. This is where the non-lawyers get it right, that we don't. And what do I mean by that? You see, when they come into ADR, they have a focus, a subject matter for them. And a lot of them are coming into mediation right now, maybe, and when they come into mediation, they're like, okay, fine. I know of someone that came into real estate. The only thing he does is real estate mediation. You understand? He's been able to look at the issues the realtors have with subscribers, and he has said to himself, this is the area I want to focus on. I know of someone who has come into mediation. Entertainment. He's only focusing on entertainment. I know of someone, fashion mediation. I know of someone, construction mediation. I know. So they sometimes, and they are not lawyers. They just been able to identify this particular niche and they are coming in. But whereas some of us, when we come in, we want to be jack of all trades. We want to do everything and all of that. So it's really very important that you have an understanding of this. Also, negotiation. I hope you're aware that the tool that is engaged in mediation is negotiation. The mediator uses the tool of facilitated negotiation because his job is to get both parties to settle. The parties make use of what is called interest-based negotiation because they are trying to basically move to get the parties to succumb to whatever it is they want. And of course, synergy partnerships. You see, ladies and gentlemen, apart from even talking about specialization, there is a need to talk about synergy partnerships. You cannot do everything. You cannot see. I do a lot of synergy partnerships, you understand? I've been able to identify some of the top law firms that I work with. Whenever issues come up, if it's construction, I have a law firm that handles construction. If it is maritime, if it is oil and gas, if it is landlord and tenant, even if it's criminal, because I know that there is no point that we're at that conversation that we're not going to possibly look at the issue of resolution of disputes. So these are the conversations that we need to start having. Conversations surrounding subject matter expertise, conversations surrounding synergy partnerships, because one, the future of work has changed. And you see, when we're even talking about the future of work changing, ladies and gentlemen, there are also certain things that you also need to understand. Because you see, yes, we are all lawyers, but I'll tell you one thing for free. You are a service provider, you render a service, and you are paid for that service now. So that means that there's only a language, the language that the marketplace understands is product. And product is divided into two parts. You have the goods, you have your services. The goods are the physical things you see. The services are what you render. You understand? So that means that there's a level of abstraction ascribed to what it is that you do. So what that means now is that, ladies and gentlemen, if they ask you, so what do? You say that you're a lawyer. Now, I feel in this age and time, that sounds a bit generic because you understand, yes, you're a lawyer, but what type of law do you practice? If I had to give you maybe 1 second or give you a minute to give me an elevator pitch on what it is that you do, what would you say you do? These are the conversations that we need to start having. And even in having this conversation, it's also very, very important that we put the concept of mediation, ladies and gentlemen, into proper perspective. It is not, you see, because first of all, you are marketing a solution or a service to a target audience that does not recognize its value. Now, you are basically, because for them, they are telling me to go and settle. Why do I need to settle? So the conversation, and because it's still evolving, and I dare say it's evolving very, very fast. You see, if there's another thing I want you to take out of this, really, is what is called ingenuity. Ingenuity in the way and manner that you already know what you do in mediation is an amicable way of having issues resolved. You know that you speak the language of peace. So how, and also, of course, you also know that as lawyers, we are not allowed to market. So we are not allowed to advertise. But how then do you do that? By talking about your craft. When you talk about your craft, then there's a presumption that you know what it is that you're doing. And at the end of the day, people will then come to meet you. So the question now is this: within the framework of mediation, what are the ways of making money? First of all, ladies and gentlemen, is training. Because I'll tell you one thing for free. Once you come into the arena of mediation, you're a facilitator, you are a trainer, because you're constantly explaining to parties what mediation is all about, So that's also another angle of training, you understand? And a stream of income, becoming a trainer. And of course, we have different flavors of mediation. We also have workplace conflict, Workplace conflict is also a flavor of mediation. Look, all you need to do is to be ingenious about the way and manner you look at it. And if it would interest you to know that as much as there may be various angles of mediation, they are coming from the stream of mediation. You could go into trainings among so many other things, and be able to then have your craft. And that is why, if there is one thing I know I talk about well enough, ladies and gentlemen, is specialization. Specialization is the name of the game, and this is also even coming to property dispute, be known, you understand, if you want to focus into this area, because the truth of the matter is this: we have what is called riches in niches, and so, having said that much, the next question there is this: how then do you become a subject matter expertise? One is to build a fountain of knowledge, and I say this respectfully, ladies and gentlemen, there is no value in free. Yes, when I'm talking about value in free, it says that, for you to make money, you need to be able to spend. For you to make money, you should be able to spend money. And when I'm talking about spending money, invest in yourself. You understand? Invest in yourself, because ask yourself one question. If you can gain so much from something that is free, what would happen when then you pay for it? So there's this limiting mindset that a lot of us have that, if it is learning and development, I cannot pay for learning and development. Invest in yourself. Pay for training, you understand? Educate yourself. And not only educating yourself, try out new ideas. Like I said, the thing about mediation is that you continue to evolve. You continue to try to once you have an understanding of what it is, you continue to try out your ideas, to see the way and manner that they work. And of course, also be authentic, because the truth about the matter is that people see through people. So you also have to be authentic. And of course, be an authority in that subject matter. Like I said, for someone like me, I don't know a lot of things. You will be surprised. I don't know a lot of things. But ladies and gentlemen, the little that I know it very, very, very well. You understand? And because I do that, my strength covers my weaknesses. You understand? And that's why coming to mediation, and I would like to believe I'm almost becoming an authority in that. Now, what are also talking about, like I said, marketing in mediation. Of course, in disseminating information about peace. Who are your first port of call? Family and friends. Networking. When we're talking about networking, attending trainings like this, going to where there are lawyers. And of course, we all know that the means of dissemination of information right now, ladies and gentlemen, is online. So that means that you need to have footprints online. If I pick up ChatGPT and I type XYZ's name, what does that say about you? You understand? If I go to your LinkedIn, you see, ladies and gentlemen, your LinkedIn is your online CV. It is where people go to check out what it is you do and who you are. So you must have an active LinkedIn. You must have an active LinkedIn. So the question now is this: how well are you intentionally putting yourself out? And we have some social media platforms that have age grades ascribed to them. I don't know how to use Snapchat. I don't know how to use TikTok. I belong strictly to the WhatsApp and WhatsApp, LinkedIn, and Instagram face. You understand? If you're the one that knows how to use Facebook, depending on your demography, I'll definitely advise you go there. Now, as beautiful as mediation may be, because you see, ladies and gentlemen, it's extremely important that we put the conversation around mediation in proper perspective. Some things militate against mediation. First is the concept of delay. You and I know that the concept of mediation is fast. So more often than not, anybody that is looking to that wants some form of delay, the advantage of delay always favors one side. So most times, some people who don't want their cases to move as fast as they should would not always want to come into mediation. And of course, awareness. Awareness is very, very important. There's still this misconceived notion of the non-bindingness of mediation. People are always trying to focus on the negativity, on the negative side of mediation. And the truth of the matter there is every form of dispute resolution has its own strength and has its own weaknesses. So, like I said, they're all efficient. And at the end of the day, you see, for me, I think it's really very important on what the parties want. A party that wants a matter resolved amicably, very quickly, needs to understand that there has to be an element of concession if he's able to make, if he or she wants to have the issues resolved. So, like I said, all forms of dispute resolution are efficient. All forms of dispute resolution, they work. The most important thing is just to know what makes one stand out. Of course, it's time to change. People that are used to the way and manner of doing things, of course, may not want to change. And I'll be very honest with you, the lawyers, no, see, because I mediate at the Court of Appeal, Lagos, Port Harcourt, Abuja. I mediate with the LMDC, and I can tell you, across board, not only in Nigeria alone, the lawyers are the problem. That's the honest truth. I can't think of a better way to put it. And I now don't know whether it's because they don't understand how mediation works, or they have refused to understand how mediation works, or they just don't see value in it. It's everywhere. So as a mediator, you need to have an understanding of the fact that, and for some of them, like I say, they will only continue to do the best with what they can. If they know better, they will do better. So if you're coming into mediation, please have that understanding that you're going to face some of these challenges. And of course, mediation as a concept, ladies and gentlemen, is not that easy. It's a lot of hard work. You understand? You're going to put in energy, you're going to put in resources, you're going to put in money. You understand? Sometimes it can feel uncomfortable. It can be like tough work. But once you have that plan, once you have that journal, you go back to it to ask yourself, okay, fine. How well am I going? That's why a trajectory is important. Know why you're coming into mediation. Know what it is that you're trying to do. Look at where you're going to, how far you are going. And I'll tell you the honest truth. You see, I don't know whether I have this in this slide. For me, the King Kong of them all, when you want to make money from mediation, is private mediation. You understand? There's something I like to call eliminating the middleman. What that is essentially means is putting yourself in such a place and manner that you'll be the go-to where mediation is concerned. So that for me, the same way we have been an SAN as a peak of litigation. So once you're able to get to that point of private mediation where you are the go-to, and of course, you know that making money is value exchange. When you want to make money, you solve rich people's problems. So the truth of the matter there is this here. Even when you decide to go into trainings, yeah, there is money in training, but how many times can I train someone? I train you to become a mediator. I train you to make money from mediation. After then, I have one or two ancillary trainings. But ladies and gentlemen, the King Kong of them all is private mediation. You understand? When you're able to start mediating for the 1% of the 1%. And that's one thing I've always said. I don't believe in competition. I don't believe that people have to compete. I'm very, very big on collaborations. I'm very big on synergy partnerships. You understand? These things are also very, very important in the way and manner you do things. And of course, to participate cannot be compelled to participate, which I explained about the principle of voluntariness, And the mediation essentially also relies on the cooperation of parties, If a party decides not to participate in mediation, ladies and gentlemen, there's really little or nothing you can do. Now, as I conclude, ladies and gentlemen, what are the opportunities ahead? First of all, you need to understand that not only in terms of the numbers, Nigeria is well positioned to become a leader in international mediation. You understand? And not only that again, and the critical steps also include institutional strengthening, the legal clarity, international alignment. And that is why at the end of the day, ladies and gentlemen, numbers don't lie. And I ask myself one question. We have over 240 million Nigerians. Why are you coming into ADR and just focusing on Nigeria? We have 1.56 billion people in Africa. You are coming into mediation or ADR and you are focusing on Africa. In the world, we have 8.26 billion. You understand? Why you're coming into mediation? Why are you not focusing on the world? So you see now that it's big enough for everybody. It's big enough for everybody. And I'm hoping that even if there's nothing you take out of this place, please do not limit your expertise to Nigeria. You understand? You need to have that global mindset. Understand that once you come into that ADR space, you're all speaking the same language. It's really, really very important. And as I conclude within 1 minute, a lot has been said, but these are the ideas. And people always ask me that, Fola, why is it that when you teach, you don't gatekeep? I said the only reason why I don't gatekeep is that I know that people, when they listen, more than 98% will not do anything about it. You understand? There's that initial dopamine rush that, oh yes, I'm going to do this and all of that. Some of them will stand, but a lot of them will not continue. So you see, a lot has been said. Like I said, you need to have a plan. But from the idealization stage, we are not talking about the implementation stage. What steps are you going to take right now? Even when you decide to take those steps, will you remain consistent at it? Because at the end of the day, consistency, ladies and gentlemen, beats intensity. And on a very final note, please understand that mediation is justice delivered differently. It is not only justice delivered differently. If it saves time, you save parties time, you save them money, it deserves fair compensation. And I tell everybody that cares to listen, ADR, you understand, will be the future of dispute resolution. And if the tree of ADR is going to be the future of dispute resolution, invariably then that means the branches of ADR, arbitration, mediation, conciliation too, would always follow suit. So I'd like to thank you all. And like I told Mr. Calvin, I will finish at 5:20, but I think I exceeded it by 4 minutes. So I will like to thank everyone here. And I know it's almost time. So for those who want to drop off, we understand, but I'll just take I'll let Kelvin let me know how many minutes is open for questions, and then we take it up from there. Thank you. So Mr. Kelvin, I'll let you handle the management of the questions. Thank you very much.
All right. Thank you very much, Mr. Fola, for your time. Thank you very much. This was a really power-packed presentation, and I mean, it was as though it should not end. And you're the best person for this session. So thank you very much, sir, for your session. One of the things that stood out for me was where you said speed is the current universal language. And aside from law, speed is the next you can say it's the air that we breathe right now with technology. And everything aside law, speed is one thing that everybody is looking out for. So nobody has the patience to be doing something in the locomotive way, in the slow way anymore. No, it has to be fast and instantaneous. So with ADR, one of the advantages that you mentioned was speed. And I really thank you for this session. And I believe that we have two people that want to ask questions. There were some questions on the chat box. I think there were two questions. I'll just read them out. And if there's anybody, please signify if you have any questions.
Oh, I'm so sorry, Mr. Calvin. I see someone saying that the volume is very low. Oh, wow. What's going on? Are you saying they can't hear me?
No, it was their device at the time, not yours.
Okay. Okay. Great stuff. Okay. Okay. So let me just okay, I'll just go through. Thank you so much. Thank you. Thank you. You can all just check me out on LinkedIn. And oh, I must also add, and I don't mean to be disrespectful. So my consultations are not free. So let's just put all of that into consideration when reaching out, you know. So free does not work for me. So you would only catch me free when we're having webinars and sessions like this. So please put that into consideration when reaching out on LinkedIn. Yeah, someone said that can I be a private mediator or must it be with the government? You can work anywhere, ladies and gentlemen. Can you set up a mediation house? Yes, you can set up a mediation house. I will talk about OASIS. So OASIS is Africa's first premier mediation hub. Was set up by Mrs. Toyola. Essentially, what she does there is that you go there to discuss anything and everything mediation. You know, so what is the best book for mediation? The best book for mediation is to come into mediation and learn things they had and learn it yourself. Bearing in mind that, look, most times when people talk about mediation, it's always spoken about subjectively. You know, so I would just advise that just come into mediation, whichever way and manner you understand it to be, and just learn the job on the rope. You understand? Try and go into have mentorship, people that will teach you what it is you need to do. Okay, fine. Okay, so thank you so much, Oluwaseun. I know, yeah, for the call. What else again? I think that's pretty much all there is to it, Mr. Kelvin. Maybe people that
Informa,
have, yeah, Ifoma, let me
or
unmute her. Okay,
have the question, you can unmute and ask your question.
okay. Hello, Ifoma. Good afternoon. Good evening.
Good evening, everyone. Good afternoon. Good evening. I am a 400 level law student at the University of Lagos. Yeah, so my question is, in practice, what skills make someone a very effective mediator? Then the second question is, where one party fails to comply with a mediation agreement, yeah, can the other party enforce it in court? That is it legally binding?
Okay, let me
That's
take your
just
first. Let me take your first question. The truth of the matter, the moment you said you wanted to ask the second one, I immediately forgot the first one. But let me try and remember what you said about the first question. So what are the skills that make one an effective mediator? I will give a subjective response to this. For someone like myself, I'm not a rigid person. I don't do well with structure, if you understand what I mean. I always like a little bit of flexibility where things are involved. And I remember when I was still very active in litigation, I struggled, you know, because the truth of the matter is when you file your statement of claim, you have a required number of days within which when you file your statement of defense. If you don't file it within that time, you have to bring in a motion for extension of time. You see, there's a form of rigidity structure where litigation and arbitration is concerned, but mediation is not like that. You know, a lot of times when you start off, you don't even know how you will end. You know, so I like the flexibility. So for me, the flexibility worked for me. Apart from the flexibility that again that worked for me, also the fact that I'm this kind of person that I like immediate value for what I do. You know, the idea of having a litigation case and it's going on 2, 3, 4, 5, 6, 7 years. Ask myself one question: how much are you going to pay me to keep me in court for years without end? The money of mediation may not be like arbitration and litigation, but 5 million here, 3 million here, 2 million here, 1 million here, 500 here, sometimes 250 here. They all add up. You know, so that's the first question. The first answer to your question, number one, really has to do with who you are as a person. You understand how well you're able to think on your feet, how adaptive you are, how you are able to think outside the box, how you are able to not only listen with intention of understanding, but listen with intention of responding. You know, so those are the skills I think that make you an effective mediator? And please understand that that is basically subjective. Now, to your second question of what happens when a party does not keep to it, please remember that the end product of a successful mediation is an agreement in terms of settlement. And you see, the terms of settlement is a contract. So if a party breaches that agreement, then there's a breach of contract. So what that invariably means is that whatever is supposed to happen to a breach of contract also happens where mediation is concerned. That's number one. Number two, if that contract is adopted as a consent judgment, and of course, if the judge, if the person does not keep to that judgment, then the judgment can be enforced. And I don't know whether that answers your question, Informer. I was just able to give a summary of it. Let me make you unmute yourself. I don't know whether I was able to answer your question, Informer.
Thank you, sir.
Okay, most welcome.
Yes, sir.
Okay, okay. Does anyone have any questions so we can finish with it? Oh, 5:30 actually. We said 4 to 5:30, so I think we're almost within time. So I don't know if you have any question, feedback, or comment. This now will be the time to ask.
Okay, so we'll take one question, and then we'll take parting words from Mr. Fola and Dr. Tolu Aderemi.
Okay.
5, 4, 3, 2, 1. No more questions.
Okay.
So, Mr. Fola, parting words.
Okay. For me, the parting word is this. Like I said, it's very two things actually. Number one, I think it's very important that as lawyers, we enjoy what it is that we do. I can't think of a better way to say it. Yes, I understand. Okay, fine. Is there money in this? There's money in everything, because you see, when you genuinely enjoy what it is you do, you will not see it as work. So that's number one. And number two, like I said, is that as much as you may play in the litigation space, ladies and gentlemen, you must play in the ADR space. I can't think of a better way to put it. You understand? Because if you're playing in dispute resolution, it's better to fully empower yourself, because where we are going to right now, you should be able to work anywhere. You understand? If you go to any country around the world. So the question I'm going to ask is that, what tools have you put in place to empower yourself for the future? You know, anything that's worth doing at all is worth doing well. So that's just what my message is to you. My message to you will be, you know, enjoy what it is that you do. Get into the ADR space. If you're superhuman, you can do all the elements of ADR. If not, just find a sweet spot. Find what you resonate with and go right into it. Thank you very much.
Thank you very much, Mr. Fola, for your intervention. Dr. Tolu, parting words, sir.
I don't know whether Dr. Tolu is able to unmute himself. Can you please unmute him? I know that I don't know whether Dr. Tolu is still here. Is he still here? Can you?
Well, here for a bit, but maybe he's no longer here. Anyways, so thank you, everyone. Thank you very much for your time and for joining us in this learning session. I believe that. Thank you for your time on this session. I believe that everybody has taken us one or two things, and it's added what we claim to do, or what we aim to do, is to add to knowledge. It's to add to knowledge. So thank you very much for your time. The link for this session is going to be sent to the groups and the cohorts later today, and then they can go back and watch it. So there's a link for cohort 1 for the session 1 and session 2. You can go back to watch it, and then we can have a good time and have a good weekend also. Thank you very much, and thank you, Mr. Fola.
Yeah, and very quickly, Mr. Calvin, I would also please say you can also follow me on LinkedIn too. I respond to messages on LinkedIn, so you can just connect with me on LinkedIn, and we can possibly take the conversation further from there. Thank you all for your time. And
can you just type in your LinkedIn, your name on LinkedIn? Just type it in the chat.
Okay. Okay. One moment, please. I think let me just put it up here. Okay. Hold on. So this is my page. I don't know whether you all can see it. You can follow me here. So on LinkedIn, I'm Fola Alade here on LinkedIn, and on Instagram, Facebook, Twitter, it's FOTEFA Mediation Academy. Can you all see this?
Yes, you can.
Yeah. So LinkedIn is Fola Alade. On Instagram is FOTEFA Mediation Academy. Yes. Thank you very much.
Okay. Thank you very much. Thank you very much, everyone, and I hope you have a good weekend. Expect the link later today. Thank you very much.
Yeah, thank you so much, everyone. Bye for now.